I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about U.S. investments in foreign businesses and foreign companies trading in the U.S. public markets. Like U.S. companies, when a foreign company desires to offer and sell securities to U.S. investors, such offers and sales must either be registered or there must be an available Securities Act exemption from registration. The registration and exemption rules available to foreign private issuers are the same as those for U.S. domestic companies, including, for example, Regulation D with the primarily used Rules 506B and 506C, Regulation S, and resale restrictions and exemptions, such as under Section 4A1 and Rule 144. When offers and sales are registered, the foreign company becomes subject to ongoing reporting requirements. Subject to the exemption under Exchange Act Rule 12G 3-2B, when a foreign company desires to trade on a U.S. exchange or the U.S. over-the-counter markets, it must register a class of securities under either Section 12B or 12G of the Exchange Act. Likewise, when a foreign company's worldwide assets and worldwide and U.S. shareholder base reaches a certain level, that is 10 million in assets, total shareholders of 2,000 or greater than 500 unaccredited shareholders, with U.S. shareholders being 300 or more, it is required to register with the SEC under Section 12G of the Exchange Act. The SEC has adopted several rules that are applicable only to foreign private issuers and maintains an Office of International Corporate Finance to review filings and assist in registration and reporting questions for these foreign private issuers. Of particular significance, foreign private issuers may prepare financial statements using either U.S. GAAP, International Financial Reporting Standards or IFRS, or home country accounting standards with a reconciliation to U.S. GAAP. Foreign private issuers are exempt from the proxy rules under Section 14. Insiders of foreign private issuers are exempt from the Section 16 reporting and short swing trading requirements and prohibitions. However, they must comply with Section 13. Foreign private issuers are exempt from Regulation FD. Foreign private issuers may use separate registration and reporting forms and are not required to file quarterly reports. For example, they can file a Form F1 registration statement and use Forms 20F and 6K for annual and periodic reports. And foreign private issuers have a separate exemption from the Section 12G registration requirements, i.e. Rule 12G 3-2B. Allowing the trading of securities on the OTC markets without being subject to the SEC reporting requirements. In the next LawCast in this series, I will continue describing the registration requirements for foreign issuers, including the F series of forms. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com or lawcast.com or contact me directly. Inquiries of technical nature are always encouraged.